Before we begin, can I remind members, as normal, and witnesses and those in the public gallery to make sure their mobile phones are turned off, please. We're here today to discuss the Veterinary Council of Ireland report on corporate ownership of veterinary practice. I'd like to welcome Veterinary Council of Ireland, Ms Niamh Muldoon, the Registrar, Mr Padder O'Scannell, the President, and thank him for coming before the committee today to discuss the report before us on the analysis of the Veterinary Council of Ireland consultation on corporate ownership of veterinary practice, which was published last July. We've been discussing this matter for the last period of time. So before we begin, I want to bring to your attention witnesses are protected by absolute privilege in respect of evidence given to the committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter to qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise and make charges against any person or entity by name in such ways to make him or her identifiable. Members are reminded of long-standing parliamentary practice to the effect that members should not comment on, criticise and make charges against either person outside the House and officially by name or in such ways to make him or her identifiable. Ms Muldoon, I now ask you to make the opening statement, please.
Chairperson, Deputies, Senators, thank you for inviting us to appear before you today. My name is Niamh Muldoon, Registrar and CEO of the Veterinary Council of Ireland, and I am joined today by Mr Padder O'Scannell, President of the Veterinary Council. We welcome the opportunity to appear before this Joint Oireachtas Committee on Agriculture, Food and the Marine for the second time to discuss the important issue of corporate ownership of veterinary practices. We look forward to continuing this discussion on an area of huge relevance and importance to the veterinary sector. The Veterinary Council of Ireland is the statutory body responsible for the regulation and management of the practice of veterinary medicine and veterinary nursing. The principal function of the Veterinary Council is to regulate the practice of veterinary medicine and veterinary nursing in the Republic of Ireland in the interest of animal health and welfare and in the interests of veterinary public health. The functions of the Veterinary Council include protection of the public through the supervision of veterinary education, the maintenance of the register of veterinary practitioners and nurses, the registration of veterinary premises, and through disciplinary action in cases of professional misconduct. In order to legally practice veterinary medicine in the Republic, a veterinary practitioner or veterinary nurse must be registered with the Council. The practitioner or nurse must also carry out the practice of veterinary medicine at and from a premises registered with the Veterinary Council. There are currently 2,933 veterinary practitioners and 966 veterinary nurses registered with the Council. We also have 752 veterinary premises registered under the Council's Statutory Premises Accreditation Scheme, at and from which veterinary services are provided to the public. These include veterinary clinics, veterinary practices and veterinary hospitals. As this committee will be aware, the topic of corporate ownership of veterinary practices is a challenging one and has been the subject of much debate. Further to our appearance before this committee in May of this year, the Veterinary Council has since clarified the position with regards to ownership and the provision of veterinary services to the public, having benefited from a period of extensive consultation on the matter. It remains the role and remit of the Council to continue to ensure the highest standards of veterinary medicine in the regulation and management of the professions. I will briefly recap the history and experience of the Veterinary Council as it relates to this issue. Historically, Section 54(2) of the Veterinary Practice Act 2005 was interpreted to prevent a body corporate from owning a veterinary practice, and this understanding was reflected in the Veterinary Council's Code of Professional Conduct. However, legal advice received by the Veterinary Council advised that the legislation does not speak to the ownership of practices, and thus the Council has no legal authority in determining such issues. The parameters of our powers, as established under the Veterinary Practice Act 2005, involves the regulation of veterinary services to the public and the practice of veterinary medicine within that service. They do not extend to the area of ownership of practices. In light of this, the Veterinary Council initially amended its Code of Professional Conduct in December 2017, explicitly stating that there was no prohibition on a non-registered person or body corporate owning a veterinary practice, provided that the practice of veterinary medicine was carried out by a veterinary professional registered with the Council. This amendment was then put on hold in January 2018 to allow for a period of comprehensive consultation with the public, stakeholders and members of the veterinary professions. The results of this consultation have been compiled in a report by Grant Thornton, offering an analysis of the VCI consultation on corporate ownership of veterinary practices, which was shared with members of this committee, along with the clerk, in July of this year. The Council commenced the public consultation in early 2018, which concluded in the summer of this year, culminating in this report by Grant Thornton. The consultations conducted, reflected in the report, include a survey of the general public conducted by market research company Behaviour and Attitudes, a consultation process whereby any interested parties could submit their views, a survey of the veterinary professions conducted by market research company Behaviour and Attitudes, research and analysis of other veterinary regulators internationally, and research and analysis of other regulated professions in Ireland. The Veterinary Council has also benefited from legal advice on the matter, and all of these inputs, together with the results of a consultation process and survey of the public, have been consolidated into this report. Overall, the responses to the introduction of corporate ownership of veterinary practices in Ireland were divided. Some were opposed, while some were in favour of the idea. Industry perspectives on corporate ownership can sway dependent on the circumstance. Analysis of other professions in Ireland, in addition to veterinary professions in other jurisdictions, is also reflected in this report. Consultations were held with different jurisdictions globally to understand the issue of corporate ownership. It was apparent from the consultations that corporate ownership is prevalent internationally, but how it is regulated varies across the jurisdictions. The majority of other professions examined allow corporate ownership to exist, with the exception of the legal profession. The Council sought independent legal advice on the issue of corporate ownership with regards to the Veterinary Practice Act 2005. This advice highlighted that the governing legislation does not provide for a role for the Veterinary Council in the ownership of veterinary practices. The Council's role lies in the regulation of the practice of veterinary medicine in the public interest. Our focus, therefore, is on the regulation of veterinary services to the public, the licensing of the veterinary premises, and the registrants who provide that service at and from those premises. Following the period of consultation with stakeholders, the Veterinary Council of Ireland updated its Code of Professional Conduct in relation to the matter of provision of veterinary services to the public and the ownership of veterinary practices. The Council provides guidance to veterinary registrants on matters relating to conduct and ethics through their Code of Professional Conduct for registered veterinary practitioners and nurses. The Code of Professional Conduct consists of the rules and principles which govern veterinary practitioners and veterinary nurses in the exercise of their profession. The Council also regulate and licence veterinary premises, at and from which veterinary services to the public are provided. Registrants are bound by the Code and the regulations relating to the veterinary premises where the practice of veterinary medicine occurs. The Council continues, as always, to use its statutory powers to ensure that the highest standards of clinical governance are employed in veterinary medicine within the state. Those standards are to be found in the Council's Code of Professional Conduct and the regulations which underpin certificates of suitability. A certificate of suitability is the licence issued by the Council to persons registered with the Veterinary Council who wish to provide veterinary services at and from a premises to which the certificate relates. A certificate of suitability for the veterinary premises is required before any veterinary service to the public may begin from that premises, and the certificate is renewed on a 4-year cycle. Only individuals registered with the Council may apply for and be granted a certificate to provide veterinary services to the public at and from a veterinary premises. For example, a veterinary practitioner cannot provide veterinary services from a premises without such a certificate being in place. The regulations relating to that certificate are one of the means by which the Council regulates veterinary services to the public. The certificate of suitability for veterinary services involving the practice of veterinary medicine may only be held in the name of a registered person. The Code of Conduct is another means by which the Veterinary Council regulate the practice of veterinary medicine and nursing in the state. The Code of Conduct and Council regulations underpin veterinary services to the public. The Veterinary Council issues the code and regulations and determines the issuing of any certificate required to enable veterinary services to be delivered at and from a veterinary premises. The update by Council to the Code on the 11th of July 2019 reaffirms that the provision of veterinary services to the public, performance of which forms part of the practice of veterinary medicine, must at all times be provided by the veterinary practitioners who usually practice veterinary medicine at and from those registered premises. The clinical discretion of the veterinary practitioner is absolutely paramount, acting at all times in the interests of animal health, welfare and public health. This decision brings clarity to the matter. The Council's words updating the Code clearly state that the veterinary practitioner provides the veterinary medicine service to the public at and from a premises certified and licensed by the Council. The Code of Conduct and the regulations relating to the veterinary premises are the means by which the Veterinary Council regulate that service in the public interest. Ownership bears no influence on the provision of veterinary services. The Veterinary Council's updating of the Code of Conduct of veterinary practitioners clarifies that only veterinary practitioners may provide veterinary services, the performance of which constitute the practice of veterinary medicine, to the public, and also strengthens the clinical discretion and autonomy of registered veterinary professionals in discharging clinical duties. In looking towards the future, the Veterinary Council recently began its period of public consultation in relation to its strategy for 2019 and 2023. This is to be published later in the year. The strategy will seek to work with partner bodies to shape the professional lives of veterinary registrants and to ensure the development and oversight of the veterinary professions continues to foster best professional practice in the best interests of animal welfare and the public. It contains the following proposed strategic objectives: leading animal health and welfare in line with One Health, One Welfare initiatives, maintain confidence of the public and veterinary professions in the Veterinary Council of Ireland processes, enable good professional practice and professionalism through education, support the health and well-being of registrants, support and develop the role of the veterinary nurse, enhance, influence and inform policy through insightful research and meaningful engagement. In conclusion, while there are a number of different challenges facing veterinary practitioners and nurses in Ireland today, the Council will continue to work to ensure that registrants continue to provide best-in-class services and that registrants are supported in their provision of veterinary medicine services, in their development as professionals and in their own personal well-being. We will continue to work to ensure that the high standards expected in the veterinary industry are upheld and that the quality of veterinary care enjoyed in this country is continuously improving into the future. Finally, I would like to thank the Chair and this committee for the invitation to address you today. Both the President of the Veterinary Council, Mr O'Scannell, and I are happy to address any questions this committee may have. Thank you.
Thank you very much, Ms Muldoon, for your opening statement. Now, members, I think Deputy Cahill was first to indicate, Deputy Stanley, Deputy McConalogue, Senator Lombard, in that order.
Thank you, Chairman. First of all, thanks for the presentation. I think this is a more serious issue for the whole sector, and I think there's an awful lot of questions that have to be asked, and there's an awful lot of unease out there. And I suppose I had phone calls from 8 vets over the weekend, and because I got were unanimous in their view anyway that this wasn't good progress for the sector, and that this was a retroactive step. But myself and my Fianna Fáil colleagues met the veterinary union, and they have put forward a number of questions. And with the Chairman's permission, I think we put those questions forward. And I'm not suggesting I put them all forward. I think we all have copies of the questions. They met all the different parliamentary parties that are at the table. I think we put forward the questions and get answers to those, and then see where the debate goes, Chairman, if that's okay.
Yeah, you're first up, and when you're first to finish your questions, we'll go back to get the answers, and then we'll go to the next questioner. Is that okay?
That's fine. At our last meeting here on the 21st of May, you assured this committee that the Veterinary Council got current specific legal advice prior to announcing the amendments to the Code of Professional Conduct in December 2017 relating to the ownership of veterinary practice. This is not substantiated by the findings of the Grant Thornton report. And could you please clarify this discrepancy?
You'll see in the Grant Thornton report that the dates of all the legal advices received in to assist the Council in considering this matter are all cited. So there were some advices received in 2014 and some further advices received in 2018 and 2019. So there are advices received from McDowell Purcell Solicitors in association with Mr Tom Hogan in 2014. There are 2 senior council opinions received in both 2018 and March 2019, and a junior council opinion received in 2018.
Yeah, but after the decision in December 2017, when the amendments to the Code of Practice related to the ownership were taken, what advice was received before that decision was taken?
So you'll see cited in the report there were advices provided to the Council in December 2014.
So advice in 14, it was 3 years later before that advice was acted on.
It's probably more appropriate if I were to answer that one in that. Thank you very much, Deputy Cahill. Thank you, Cahill. In fairness to our current registrar, she would not have been around at the time, and for those sort of questions, we could have prepared, or she could have prepared, but she wouldn't have known. She wouldn't have been there. Mr Hogan's advice was given initially in the presence of myself and 2 other council members in his room, and it was then followed by written advice. But it was the subject of continued discussion from that right up to 2017, and it was always referred to as the advice that we had. I don't know if that clarifies.
That's fine, yeah.
You complete, Deputy Cahill?
Yeah, someone else asked the next question.
Okay. Was it Deputy Stanley was next, I think?
Just verify the order. As I understand what you're doing is that if you have a question outside of those supplied, the list of questions that we have.
But you're next up, Deputy Stanley, for whatever questions
we're leaving. They're being taken together. Are all those questions?
But that was like you're next up. Whether you want to ask some questions off that particular list, right, or whether you want to go outside that, it's up to yourself.
Okay, thanks.
But you're next up.
Yeah, no, just one of the questions I wanted to ask the President and the Registrar is that the provision in the code that requires a veterinary practitioner to ensure that arrangements are there for a 24-hour on-call service. Would this isn't binding on an unregistered body or corporate body? Just you might give me a response to that, because obviously that's a big issue. And similarly, from my point of view of myself and the Senator here from Sinn Féin, we've had contacts from veterinary practitioners who are very, very concerned about the changes. So, and that is a key issue for the farming community. That will be 24-hour cover.
The requirement to provide 24-hour care is linked to the licence, the certificate of suitability referenced in the opening statement that attaches to a premises from which veterinary services can be supplied. So it is only a member of the register of veterinary practitioners or nurses that can apply for such a licence, for such a certificate. And so that requirement is tied in with the licence to the premises, required for any practice, clinic or hospital around the country.
Okay. And the other question I had for you was just in relation to trying to work out how this is going to pan out in practice. That typically, if a practice is taken over, where there's, we say, 3, 4 or 5 vets operating out of, for example, and it's taken over by a corporate body, and you then have an employer-employee relationship. The employer is the employer, okay, but the employer isn't a professionally qualified person, and a huge concern around this is that the employer would make decisions that may not be in the interests of the veterinary profession or in the interests of animal health. For example, maybe the type of drugs used or the types of medicine used or the practices carried out by vets. And there are reports of companies operating in other jurisdictions where there's time limits put on vets making calls. I'm not too sure how that would work out in terms of in practice in rural areas, maybe where people have to go into remote areas to deal with animal health issues and treat treat animals. But I'm just trying to, you went ahead and changed the code of conduct. Did you have regard to this? Because, the employer, I mean, I've been an employee, as I'm sure a lot of these people in this room have been, and regardless of who is qualified, be it on the factory floor or workshop floor or office floor, the owners would make the decision, and the decision would be binding. And if you didn't like it, you could take the way out. It was my way or the highway. And the problem here is that we have a very, like I certainly, and I would, maybe other members have received different feedback, but I have never received a complaint, or I've never heard a complaint from farmers overall in relation to the veterinary profession that we have in this country. We have a network of veterinary practitioners who have served the country well, and served the agricultural community well in particular. And the concern here is that if this is corporatised, for want of a better word, and that services, the nature and the culture and the practices will change, and the vets that are part of that network, that serve areas in the constituency that I live in, Laois Offaly, for example, that they will no longer be that relationship with the farming community will break down. The quality of the service being provided will lessen. The professional conduct of vets, because they won't be the master. The master will be the owner of the corporate body. That's the concern that we have here. And in your statement you've alluded to some of this, but I can't see how the vet, the professional qualifications of the vet, their professional experience, years of experience, sometimes handed down from father to son or from father to daughter in some cases, that has been built up over years and generations, and that will be lost. You're not concerned about that, and in terms of just changing the code of conduct to facilitate this, that this should have been looked into further.
So we see that ownership bears no influence on the practice of veterinary medicine. So to be able to practice veterinary medicine, you have to be on the register of practitioners, for starters. You then have to apply for a certificate or a licence for that practice from the Veterinary Council. It is through, in part, that licence that we can be absolutely confident that ownership will have no influence on the provision of those services. The standards enjoyed by our agricultural sector across the country will be maintained, and that is the role of the Council, to make sure that those standards are upheld. We're all so fortunate to have the quality and standards that we enjoy in this country, and the Veterinary Council will not be found wanting in allowing any diminution of those standards.
Just one further question. Just in relation to, obviously, a lot of people would disagree with you in relation to that. But just in relation to, to ask, there's no, as far as I can see, that there's no pressure in terms of competition law to change the code of practice, from the point of view that, that is clear from European Court of Justice rulings in the past that, in the case of other jurisdictions, that there haven't been any rulings to say that, that you have to allow corporate bodies or corporate interests to take over practices. Is that your interpretation of it?
Well, you'll see, as referenced in the report, the Consumer and Competition Authority in 2008 gave a recommendation in relation to the ownership of veterinary practices. The position of the Council is that they do not have the legal remit to make a comment on ownership. They never have. They don't collect data. They don't ask any vet or nurse around the country who owns the practice that they work in. They have never collected that data. The focus of the Council is in the effective regulation of that service, to make sure the standards are high. Our vets and our nurses are educated to the high degree that they are. Continuing professional development continues throughout the continuum of their professional career, and dealing with any issues of disciplinary matters.
But surely, as part of we're part of the European Union, and it's absolutely clear from previous judgments in regarding other jurisdictions that there is no onus to to change the code of practice and to allow for the corporatisation of veterinary practices. Regardless of the competition authority, I mean that that, was that case not put to the competition authority that, the supreme body here is the European Court of Justice. It's not the Irish Competition Authority or any competition authority in any particular state. The European Court of Justice is the final arbitrator.
Yes, and I suppose whether or not restricting ownership, whether or not that will be anti-competitive, that is certainly one matter that has been discussed. The advices received by the Council are that the Council has no legal or statutory role in relation to ownership. That's their position.
Thanks, Deputy. Deputy McConalogue, please.
Yeah, thanks, Chairperson. Maybe to go from where Deputy Cahill left off, I suppose just to welcome our guests here and to outline the background to it. I think it's a welcome opportunity, but there's a lot of concern around the country in relation to the impact of the decision to open up ownership to lay ownership. I've seen an example in my own county in recent times where a practice has actually closed down after having moved into lay ownership. Now this is a move which was lots of concerns were raised about in advance by vets, and particularly by Veterinary Ireland, which is the representative body for the vast majority of practice vets in the country. I think they represent about 1,200 out of the 2,000 practice vets in the country. They're the only representative body, and they flag concerns in relation to that. And they've done a lot of research, and they've outstanding concerns and questions on behalf of vets which they'd like to have answered, and they presented a number of them to us as members, and we felt that the best way of getting answers and eliciting that information was actually to go through the questions that they would have, because it is important to understanding the rationale behind getting to this stage, what can be done about it, and the impact that it's going to have unless it is changed and addressed, whether that be through the Veterinary Council or whether it be by looking to legislative change. And any impacts around that. The second question we had following on from Deputy Cahill's was related to Deputy Cahill's first one, and it is that in the submission by the then registrar to this committee on the 24th of January 2018, the registrar stated that legal advice was obtained on the issue. And the question is, has the Veterinary Council documentary evidence that would substantiate this statement that there was legal advice? I know it predates the current registrar, and Deputy Scannell dealt with this. But was it the case that legal advice that the Veterinary Council received, first of all, was in writing? And second of all, did it deal with the issue of lay ownership, or did it just deal with the issue of incorporating veterinary practices? Because obviously incorporating veterinary practices could be done by vets specifically, whereas the issue of lay ownership is a different issue. And was that advice in writing, and was that advice specifically in relation to the issue of lay ownership?
Mr. Scannell or Gerard?
I'll take that.
Be okay, yes, sorry.
Deputy
No problem.
McConalogue, thank you for your question. In the Grant Thornton report, so you'll see that there were 4 sets of legal advices in writing received by the Council. So in it was actually December 2014, the Council received legal advice on whether a non-registered veterinary practitioner could have an interest in a veterinary practice. So I think that probably answers your question.
Okay. And that was in writing?
That was in writing.
The next question I have is if the Council had sought relevant specific legal advice prior to the changes in code in 2017, do you think that we've been in a situation where non-registered persons are currently operating veterinary practices outside of the regulation of the Council and in contravention of the Veterinary Practice Act of 2005?
So I'll refer back to my opening statement. All aspects of the practice of veterinary medicine come under the remit of the Veterinary Council. We're the regulator. There's no aspect that we can't get to. Ownership is not within our legal remit or our particular focus, but the practice of veterinary medicine is. So there's no question but that a non-registered person would practice veterinary medicine. You must be on our registers. You must be a qualified vet or vet nurse to be able to practice. Equally, to work, to be able to practice in this country, you operate from a premises. That premises is licensed by ourselves. So we know the size of that premises, we know all of the details in relation to that premises and all those individuals that are linked and working with that premises. So there's no question but that all aspects of veterinary practice are within our control and and we are the oversight body. There will be no diminution in terms of standards. We are absolutely confident, and it's important that this committee has the confidence in the council that it is in a position to effectively regulate.
And just if I can delve further in relation to the legal advice that you would have received in relation to the lay ownership and prior to the decision to change the code of conduct or the code in December 2017. You indicated previously that legal advice indicated that you didn't have any specific role in relation to legal ownership or who could own it. But I mean, the legislation is silent on the matter. So, I mean, what did the legal advice say to you in relation to your capacity, given the fact that the Act was silent, to actually continue with the code that you had previously, as in prohibiting lay ownership? And because that option was open to you. And how can you elaborate on the nature of the legal advice you got that indicated that you didn't have that capacity to continue as was before?
Certainly. So, Deputy McConalogue, in December 2014, the legal advice received was on whether or not a non-registered veterinary practitioner could have an interest in the veterinary practice. There were further advices, specifically in relation to ownership, that were received then in 2018 and 2019.
Yeah, but I'm asking for the detail of that advice. So, I mean, what was so solid about that advice that meant you couldn't continue with your previous code which prohibited lay ownership? Because the Act is silent on the matter. So did that legal advice not leave it open then and give you discretion that you could have continued to prohibit lay ownership on the basis that it could have an impact on the operation of a practice?
See, you're querying the advices received in 2018. So we have
No, 2000, prior to the decision and to change the code in December 2017. That initial advice.
So that advice was on whether or not a non-registered practitioner could have an interest in a practice. It wasn't specifically in relation to ownership and whether or not the council had a role in relation to ownership. Those advices were more focused in 2008 on that particular matter in 2018 and 2019, when, as referenced, there was a decision taken in December 2017. That decision was taken in the absence of a period of consultation, and so that those amendments were stayed in the code to allow for further advices and a period of consultation. And I suppose it's that 18-month period of consultation which has culminated in the Grant Thornton report and the decision of the Council in July of this year.
Okay, so there wasn't the advice that you received prior to the initial decision to change the code, which allowed for lay ownership. That decision to change the code was later paused and needed wider consultation, but in advance of the initial decision to change the code to allow for lay ownership in the future, what I'm hearing here is that the advice wasn't very comprehensive in relation to the specifics of the legalities of allowing lay ownership or not. It was around, can you elaborate further on that? It seemed to be around the opportunity for somebody to have an interest. I'm not sure what having an interest might mean and what the difference between that and ownership is.
So, as set out in the report, and it's actually the legal advice from Mr. J.P. McDowell from McDowell Purcell Solicitors and Mr. Tom Hogan, Barrister at Law, stated, and it is quoted, "There is no prohibition on an unregistered sole trader or a partnership comprising of one or more unregistered persons or a body corporate with one or more shareholders being unregistered persons employing a registered person to apply for and granted hold a certificate of suitability in respect of a veterinary premises." So that is the nature of the advices that were received in December 2014.
If I could also add, it must also be taken in context of very regular questioning. Can a corporate body buy a practice? Can it not? And we've constantly tried to hold away from it. Corporatisation was occurring right across worldwide and occurring in other jurisdictions, as is mentioned here earlier. So the pressure was on at all times for council to come up with an answer, And we kept saying, no, get your own legal advice, get your own legal advice. But it became clearer that we were going to have to come up with some answer on it, and it was from that legal advice that we were using in December 17.
Yeah, but I mean, that legal advice isn't particularly directional in that it says there is no legal impediment, but it doesn't specifically require you to change your code of conduct either, in that it doesn't say that there is a legal a legal impediment, there should be a lay ownership allowed. So it would strike me that it did leave it very much in the Veterinary Council's court as to how you might proceed.
It would have come at a time also that we would have been very much aware that there was laypersons involved in practices, even though our code had various views, or not various views, but two views that could be read as being contradictory to each other. So I don't have them with me here, our former code, but there were things taken out of the former code in 2017, and then that statement went in 2017, when almost immediately we realised we really needed to have done an awful lot more consultation. We really needed to have widened this, which we did do, and that's what we're presenting in front of you today.
Can you elaborate just a little bit on that in terms of what you mean that there was lay involvement previously in contradiction of the code?
Well, lay ownership. Any vet that was married, the spouse at 50%. If there was, in fairness, if there was a retired vet who was no longer a vet, but their son was continuing with it, but the retired vet may still actually own that premises. So we would have known of existing many of those. But they weren't creating it. What was creating the question was people asking us, registrant asking us and non-registrant asking us, what is your view of 54(2)(c), where it says a corporate body cannot offer the service. But it was that's where it really hinged. How can a corporate body offer the service? But it's not. It's a vet that's carrying. A corporate body is not a person. It's a vet that's carrying out the act. So it was quite unclear. And even on the legal side, you could ask a range of barristers and solicitors, and you would get a range of answers.
Lombard.
Yeah, very interesting. First of all, thank you for your presentation, very informative. Could I ask about when you made the decision itself? Could I ask about conflict of interest and how that was determined by the actual council itself? What protocols were in place for conflict of interest, and are they in line with the 2005 Act itself? Take into consideration the conflict of interest, if I could say it, on a local authority level, or in our kind of work would require us to declare it, to have it minuted, and then to leave the meeting. Does that apply with you regarding conflict of interest, take into consideration in the 2005 Act?
Yes, good afternoon, Senator Lombard. Yes, as with any regulatory body, we have lots of procedures around conflicts, standing orders around the conduct of council meetings and our committee meetings. So any member who has a conflict is requested to declare that conflict in advance of any particular agenda item to either the chair of the committee, the chair of the council, or indeed to the registrar. They would then usually be expected to absent themselves from the discussion and or the decision.
And would they leave the meeting? Would they leave the actual physical meeting?
Yes, usual practice. If somebody declares a conflict, they would leave the meeting.
And are you happy with this negotiations regarding, or this actual remit regarding the 17 December meeting and the subsequent meeting, I don't know the date now, that all those conflict of interest issues were all dealt with appropriately?
Yes, any decision of the council is a valid decision, and the council is satisfied that all matters are in order.
Okay, so it was declared, minuted and left the meeting, anyone who had a conflict of interest. And I understand you aren't at these meetings.
I'm reluctant, Senator Lombard, to get into specifics because I wasn't present at the meeting, and I'm not sure if it's I suppose the level of detail required in these matters. But the decision of the council was taken in the usual course, and it is a fully and valid decision of council.
I can add to that. I was present at the meeting, but again, I'd be very reluctant to go down the avenue you wish to bring us down. But tomorrow, that we will be looking at a report, and we're having a meeting, council meeting on tomorrow, and there may be something that will be arising from it. But in fairness, we will always be checking what you have said was exactly the case. If there's any interest conflict of interest, or even the perception of a conflict of interest, we were always asked to declare it, and you would declare it and you would remove yourself from the room. And even on my own, looking back on it and going back to any presidents and past presidents, they're minuted, and I think looking back over very short periods, 17 or 18 removals from the room. So that would be the case. But in fairness, December 17 and digging into specifics, we will be dealing with tomorrow and perhaps in future meetings, down the line. This particular item that we brought to you here today, that is to do with the corporate issue and whatever, was described to you by myself as coming from a council member before, sucking the oxygen out of the room. From the moment December 17 and January 18, a huge amount of effort by the 19 council members have gone into all of that stakeholder, all of that work that's gone into it. So in fairness, looking back is something that we may have a privilege now, wouldn't have had. We had a change in registrar, we had a second registrar hardly in a handful of weeks. There was some issue arose, we had to have another registrar. That registrar could only attend for 1 day a week, though we weren't aware of that at the time. That rolled on for a while, and then we had another registrar, and then we were recruiting, and we now have our full-time registrar. So in fairness, the privilege of looking back is something we will be doing going forward.
And that meeting tomorrow is a council meeting
It's a
tomorrow?
full council meeting. There's many issues on the
Which
papers.
one are you referring to?
The council meeting.
Oh no, which item on the agenda tomorrow?
Oh no, sorry, you were asking about December 17. Was there a conflict of interest? But anyway.
Okay,
Thank you.
Sorry, Deputy Pringle and then Senator Daly.
Yeah, apologies. Wasn't in for the start of the meeting, and had to step out for a few minutes. Apologies for that. Just two quick questions, just in relation to it. Just in relation to the certificate of suitability and the fact that there has to be a registered vet that manages the company on behalf of whoever the other bodies is. I suppose, from your point of view, or from the Veterinary Council's point of view, if the company goes against the views of the registered person, is that desirable, or is it something that you would agree with, or whatever? Now, obviously, probably to answer my own question, the company would have its own set of rules and stuff like that, then whether the individual complies with it or not. But would you look at the set of rules that the company has to see are they compatible with veterinary practice? I'm thinking of, maybe like as happened in Donegal, I think, in the recent case where the person who was responsible, the vet, wanted to go do evening cases and stuff like that. The company didn't want that, and the company ended up closing and relocating and cherry picking customers and stuff like that there. So is that something that you would take a role in or a responsibility for?
Pringle, if you don't mind, we won't talk about specifics in Donegal.
Yeah.
We'll talk about an abstract case, an imaginary case in Athlone.
Right, okay.
So how we would...
Where the company went against the views of
Dublin, County Louth. So the way, as you've referenced, any veterinary practice has to hold a particular licence granted by the council. So you have to be a registrant to apply for that licence. So in the form of words approved by the council in July of this year, it references the clinical discretion of the registrant being paramount, and that is where we see the role of the certificate holder or the licence holder. We would see that the role of the licence holder will have full power and control over all matters relating to the practice of veterinary medicine, all clinical matters. So we won't be getting into the devil of the detail in terms of company structures. That's not our concern, how any business is structured. Our concern is how the practice operates, how veterinary medicine is delivered, how that service is provided. That's where we as a regulator, we have a very strong focus in making sure that the service provided to the public, to the benefit of society, is of a particular standard and of a safe standard.
But the standard is set by the certificate of suitability holder, not by the company.
That's how we... Yes.
And how would you police that then if the company is breaching what the certificate of suitability holder is saying? How is that policed then from your point of view?
So in theory, if you have a premises in Drogheda, in Tullyallen, in Athlone, in Ashburn, the council has a whole range of regulatory powers, on which it can act. So arguably it might send an authorised officer in to conduct an inspection of that premises, of that practice. They might sample the medical records of all the various clients. They might look to make sure that all the controlled drugs are, are validly scheduled, documented and secure. So, and equally, if there were, particular findings, well then the council would take action based on those findings.
And with standard of service to the customers, the clients, would that be part of the remit of that investigation? Or?
Absolutely, because the standards, in the delivery of veterinary medicine is exactly, I suppose, our area of focus. So, for example, the provision of 24-hour care, that is linked to the licence to each premises, each veterinary premises licensed by the council around the country, 752 of them. So you say the provision of 24-hour care is linked to that licence, as can other matters be. But absolutely, the standards of the service delivered is something that we would be interested in.
So that would be a condition of the licence would be a 24-hour care and 24. So if a imaginary person or corporate body breached that, what would be the outcome, or how would that be pursued, or whatever?
Well, you see, no corporate body can hold that licence. You must be a registrant. You must be registered with the Veterinary Council to be able to hold that licence.
But if I say, for the sake of argument, I'm the registrant and I'm registered by the Veterinary Council working for a body, and I say that this should be 24 hours, but they say, no, we're not making it available 24 hours. Well, how is that resolved?
Well, so if that scenario were to arise, in a given situation, well, then the council would probably look to conduct an investigation, to send out an authorised officer to carry out an inspection, and then take whatever actions were required arising from any report.
But where my employer was saying that I should be not doing out-of-hours service or not doing anything like that there, that's in breach of your standards?
Yes.
And, right, okay.
If I could, and it might add, one of the benefits of the really deep, in-depth looking in at the Act is the realisation, or a little, not so much the realisation, but the encouragement to Council to use an awful lot more to strengthen the role, which is something we'll be doing much more going forward. But this Act is something it's an envy, because this particular certificate of suitability, which is the certificate for the premises, is not in many other Acts or any other professions across many other jurisdictions when we did go looking. And from it, if we pull back a little bit, before ever we talk about an owner or a corporate body laying down rules and regulations, there's no service to the public until a registrant applies to us to open a service to the public at and from a certain premises. So that's the first step. That's the hands on the wheels, like we did say when we were here last, that it would be very, very important for ourselves that there would only be 3 parties on the playing field. And the hands of the wheels would be on the vet's, would be the vet's hands only, or the registrant's hands only, and that's on the certificate. So the owner behind is, in fairness, there will be contracts between them, but they can never, that contract can never come across the provision of the service that's in the hands of the veterinary practitioner that applied to ourselves for that certificate. The certificate is only for 4 years. If any issue arises during those 4 years and he or she applies for the next 4 years, well, we can refuse it, we can revoke it, as I said, revoke or refuse, we can re-grant it, or we can grant it with conditions. This is all in the primary legislation. So it's a very strong Act, and it gives us fantastic control over the provision of service, which I think is a huge step forward, because it means that, as we have said in our opening statements, the Registrar has read out there, the owner that you're referring to, with the employer saying one thing or saying the other, the first person to speak is the cost holder. The power is in the hands of the registrant that is opening that service, providing it to the public, 4 years later applying to renew the continuation of that service. So if an issue were to arise that concerned that registrant more than enough, that registrant can move next door and apply for a certificate next door, and on goes the service.
But I think you're missing it. Sorry, Chairman, if you could. I think you're missing it. I think you're putting too much power at the hands of the
registrant to apply to open the service.
Yeah. Because in that situation, he's employed by the body that owns the building, and that there. So he's actually working for them, implementing your rules, but at their discretion.
Well, we did put in it, sorry, we did in the code clarification there are 4 items, and one of them is that the registrant must not enter any contract, partnership, arrangement or otherwise of any type that in any way affects their ability to uphold the code, uphold the regulations related to certificate of suitability, uphold the parts of the Veterinary Practice Act and any regulations laid down by the Veterinary Council of Ireland on it. So it is very powerful what has gone into the code following the stakeholder consultation. It is the service is the veterinary practitioner providing the service. The user is the public, and we're the regulator. There's nobody else on the pitch.
Well,
there's nobody else on the pitch.
In your mind, there mightn't be, but there actually is. In your mind, there mightn't be, but there actually is. I would contend.
Well, they wouldn't. If an issue were to if an issue were to arise and it were made known to ourselves, we would be concerned because we've given that licence to open that service to the public, a veterinary service to the public. We've laid down codes and rules and regulations, and if they're not going to be upheld like we had asked of them, we can put stipulations in, or we can consider advising the registrant to move elsewhere and continue that service from elsewhere.
So the licence to provide the service is in the name of Joe Bloggs rather than the name of AN company?
It can't be in the name of a company. The primary legislation specifically says it is only the registrant who practices veterinary medicine or veterinary nursing at that premises.
On the point, I think the point that Deputy Pringle is making, you said there's 3 parties to the whole equation. But effectively there is really 4 parties, though, isn't there? You have the potential owner, who may not be the veterinary practitioner, who could determine the hours of work, let's say, for example, who could determine the prices of the different procedures that are going to be undertaken by the veterinary practitioner. And those prices could be substantially over and above the normal practices, over the normal prices. How is that going to be regulated? So effectively there is a 4th party coming into the picture that wasn't there previously. Am I right to interpret that right now?
Well, if the certificate holder, so the person who is responsible for the provision of the service at and from that premises, if that person has an issue with a 4th party, be someone that they're in contract with or part contract with or partnership with or renting or doing whatever they're doing, they will have, before they went in there, they'll have insisted that they have clinical autonomy because we put it into the code. They must uphold their code. And if they found that they're having some difficulty, they will have to draw the attention of the person on the other side to say, actually, I have to have, and it's in my contract. If they then find that they don't have the power to do so, they indicate to us, and we would immediately have concerns about that certificate applying to that premises. There's somebody, a 4th party, coming onto the pitch. So we would be strongly advising that either they sort it out or the registrant who has applied for the certificate applies from another premises and continues on the service.
But the 4th party, effectively, this mythical 4th party could, in theory, put the main player out of the market.
Not necessarily, because the main player would apply for another premises. There's no restriction on what premises they do once the premises reach the standards that we have applied for. So he could open up in Upper Drumcondra Road number 2 as opposed to Upper Drumcondra Road number 3. He provides the service.
I mean, companies coming in to buy out practices will be putting non-compete clauses onto vets in the event that they were to leave them and that they couldn't actually set up in the same area again. I mean, would that not be the expected practice by businesses coming in and therefore completely impede on that, and also put a big cloud and a burden on that vet's capacity to have freedom of movement and as well their capacity to properly exercise their responsibilities?
Deputy McConalogue, I'm sure you're right. I'm sure non-compete clauses will be a feature as they are in any legal arrangement, but they are specifics between 2 parties entering a legal arrangement that the council can have no hand in. So you're possibly right, but what you're and equally, Chairperson, to come back to your point, there's no owner, there's no company.
There's a fourth person very much in the equation there, then, because I mean they have.
That's a separate contract.
But bear in mind, Deputy McConalogue, that any veterinary practice can only deliver the services from a premises licensed by the council, and to hold that licence, the applicant isn't the owner, isn't necessarily or it can't be a company. You have to be on our register. So regardless of ownership, the delivery of the service is through somebody on our register. So they control the licence, they hold the licence to deliver the service, and we are stating that they must have full clinical discretion in delivering that service. It's imperative for public health.
One again, Senator Daly is next now, please.
On the same line, Chair, I'm not going away from this, because I can't believe what I'm hearing. You know, being honest, it's akin to the one thing that's coming into my head is what I'm after hearing here for the last 10 minutes is the very same as a bouncer outside a nightclub standing watching a 16-year-old getting an ID of an 18-year-old and saying that'll be fine, lads, go on in, it'll be all right in the night, there'll be no problem. Like, I've worked in companies both as a manager and as an employee. I've never been asked, and even if I was, I don't think my signature could or should have been accepted to sign on behalf of management, on behalf of the owner. I was always answerable to them. Like, what you're basically saying here is that I can buy a veterinary practice in the morning and I can literally ask any vet, qualified vet, who is prepared to sign my application, to sign it for me, put his letters behind it. He doesn't necessarily, you don't even have the checks and balances to find out, is he an employee of the person who owns the practice going forward or who owns the building? And even if he is an employee, if he decides, well, I'm after signing that, I'm going to go by what I've signed, I'm going to live by what I've signed, I'm going to provide 24-hour service, and I as his employer decided that's not economically viable for me to be sending a lad out at 4 o'clock in the morning to deliver lambs. We might part company by the end of the week. Have I still got a certification for the coming 4 years? But what check, you've given me no indication here in your report or anywhere of what check you made to know what his role was in that company other than he was a qualified vet and he signed the application, because you've been ignoring the fact that there's a fourth party in the relationship. And is it not true that in recent times, the Department of Agriculture, in the context of TB eradication scheme, has already stated that the service provider cannot be an employee of the practice? And if that's correct, which I'm led to believe it is very much correct, can you answer that to me in the relationship that you have allowed develop here by ignoring, totally ignoring, because it suits you to ignore the fourth party in the thing? Like, you're undermining your own role as the policer of this here by turning your back on the fact that you will accept a signature from anybody on anybody else's behalf wants to have the letters that they received in UCD or where else behind their name, and you're not even interested in what their role is within that organisation other than to have the letters, to have the qualification, and they may not be working under the licence you have granted in the building that you have granted the licence for a week later.
Senator Daly, I can't comment on the TB matters, so I won't stray into that. But I mean, you're dealing with members of a profession. So in the same way, you can't buy a solicitor's signature, you can't buy a pharmacist's signature, and you can't buy a doctor's signature. These are members of a profession. They are bound by a code of professional conduct. It is not a case that some company is going to come in here and buy the signature.
They may also be bound by a contract
name.
of employment under the new circumstances. They're bound by a contract of employment if they're working for a fourth party.
They may be, but in applying for this licence, the clinical discretion rests with the registrant. The registrants are a member of a profession. It's not the case that any member of any profession is going to sell their signature, for cheap use by another. It just. There are higher standards expected from society by all professions, and veterinary practitioners and veterinary nursing no different. So I don't foresee the circumstance that you outline as being problematic. That said, if it's a case that individual nuances within the area of veterinary practice prove to be problematic, the council will not be found wanting in terms of coming in and playing its role. Our job is to make sure that there is effective regulation. Our concern is for public health. Our concern is for society. Our concern is in the public interest. It's not the case that we're going to turn a blind eye, to substandard or poor practice. It simply won't be allowed.
Are you confident of your role?
Yes, absolutely.
In policing this, when you're policing employees, and you're not even. Not that you don't even have contact with the employer, you're actually denying the employer exists. So, how can you have confidence in your own role within this whole sector when you're totally, you're adamantly, and you're not going to change your tune here, but you're adamantly arguing the fact here that the fourth person doesn't exist in this, that it's a three-way street. So how can you have confidence in your own role to evaluate or to police this whole sector?
So, Senator Daly, I'm the first to acknowledge this has been a really challenging matter for the Veterinary Council, for the professions, for all of our stakeholders. But, and there are areas that it's a changing environment, so there will be change and updates and reform required by the Council in different areas. All of that is in place, is coming, is being developed. We are absolutely confident that we can effectively regulate the practice of veterinary medicine. We wouldn't stand and sit before you today if that wasn't the case. We would be beating on your door looking for legislative change, looking for amendments. We wouldn't be discharging our statutory duties under the Act if we weren't effectively regulating. We absolutely and confidently believe we can do that. If that position changes, if through the passage of time we discover that there are areas, gaps, difficulties that we can't involve ourselves or that we can't be effective, we will not be found wanting, to come forward. But the standards will remain high. We are absolutely confident of that.
So just briefly, Chair, just in conclusion, you said you'll regulate if the practices are not being fulfilled. It's well documented, without mentioning specifics, it's well documented the services have been withdrawn because of corporate ownership. Have ye taken any sanction in that area, or with that practice, or with them individuals who are on your register?
So, Senator Daly, I hope you can understand we can't comment on specific matters because they may be matters that will be considered by the Council in due course. So it wouldn't be fair to
they're in the
comment on any
public
specific
domain.
matter.
They're well documented.
There has been media coverage around some practices which the Council
Well, you can't tell me if
understand.
you've taken sanction
So
with
we
any
understand
individual.
that some practices in the country have been closed. So it's not a case that there are poor standards of care, it's that the practice has been closed. But I'm reluctant to comment any further for no reason other than it would be unfair because there may be matters that will come before the Council for consideration in due course.
I'll let you back in.
Just two little things. What you said there, that someone would sign the form, Senator Daly, somebody would find the form and then be gone again. One of the, written in primary legislation, the certificate of suitability is granted to the veterinary practitioner who carries on the practice of veterinary medicine at the premises. But it then goes further and it gives reasons why there may be restrictions put on it in the future, or it may be revoked. And one of the ones is where the veterinary practitioner no longer practices veterinary medicine at or from the premises. So what you described there, 2 days later gone, automatically that certificate is gone. So the entire control of the practice is in the hands of the vets. That was very important for ourselves because we can't regulate non-vets. We can only regulate vets or nurses, members of the profession registrants. So it was very important for us, whatever we put into the code, that it meant that the veterinary practitioner and the veterinary nurses, the registrants, had the full and ultimate control of the provision of the service to the public. If there was any issue from the public's perspective, they could come to ourselves. If there was any issue from the provider of the service, they could come to ourselves, or they could sort them with themselves on the ground. And there are contractual issues. Obviously, there's certain contractual issues about the practice you're trying to refer to there, and those issues will obviously we'd need all of the information before we could pass comment.
Are you familiar with what I mentioned with regard to the Department of TB eradication scheme?
I am, if you wanted to, yeah. That was an issue in relation to payment and the payment and the withholding tax. And heretofore, the department were paying the younger employees, or not so much younger, but anyone who's an employee of the practice carrying on the TB test, whereas the TB test, it was the practice that was asked to do it. So what the revenue clarified for the department, and the department then clarified for ourselves and asked us to sign the document to say whether we were an employee or an employer. And what it said was, to be the service provider that was to be paid the money for the TB test, you had to be the employer, not the employee. To be the service provider who was to be paid for the test and therefore have the retention tax deducted from it.
You had to be the employer.
You had to be the employer. That's what the letter said.
So if you're a non-registered veterinary officer and you're the employer or the owner of the practice, how do you get paid in that circumstance?
You couldn't, actually, according to the revenue for the TB test in that case. According to the department, it was the department were writing to us, and we had to sign the form to clarify whether we were an employee or an employer of the practice.
Do you not think you have a role then with regard to that one instance when it comes to ownership and practicing?
Well, in fairness, the Department of Agriculture have it clarified, and we've all signed, any of us that do TB testing have all signed that document, who is an employer, who is an employee. It's something, in fairness, Senator Daly, something that may come further on as the certificate. If we felt it was required, we could ask on our certificate of suitability application, which comes in every 4 years, or we could ask on the registration, which is filled and signed every year. So if it was something we thought we needed to delve into, definitely we could. But the Department of Agriculture made it very clear that the service provider who was to receive the money had to be the employer. They made it very clear.
So basically, in layman's terms, of my reading of that, so is that it means if you're to represent your people, you have to have an input into ownership, because it means one of two things. Non-veterinary owned practices will not be doing TB testing, and we all know what that's going to lead. So you have to have a role there.
Funny, it's not what I would see, and I would marginally flippantly ask you, do you know who owns my practice? But I would be the employer, but I may not be the owner. I may not actually be the owner, and definitely during the bad times I was not the owner. AIB owned me. AIB owned me. But they never told me.
That's a very flippant answer.
No, it's not. I'm trying to explain.
We're all answerable to banks in different scenarios. We could all say somebody else owns our car or our house or our home or whatever. That's a very flippant answer now, and what's a very, very serious. It's not acceptable as an answer.
I was loaned to the point that the bank could have sold me out, but they did not.
They weren't doing your invoicing and they weren't doing your testing.
No,
they weren't
that's exactly
providing the
my
service.
point. That's exactly the point, Senator Daly. That's exactly the point I'm making. That I am the employer inside it. I am the employer in that particular instance, and I signed that piece of paper, so I could be paid for it. So there would have to be an employer if the TB test is to be supplied. Would be my read from what the Department of Agriculture has clarified for us. If we're doing TB testing, to be paid for that TB testing from the Department of Agriculture. But it's only for the
You have to be the employer.
You'd have to be the employer.
But if you're employed by a corporate, you're not the employer. So how do you get paid for doing TB testing?
Become whatever you sort it out at your own level. It wouldn't be an issue for the Veterinary Council to get involved in if you wanted to provide. Reading the letter and my understanding, but the Department of Agriculture could clarify this an awful lot more to you, and it really should be. It's their letter to us. To us as registrants rather than to the Veterinary Council. I don't believe they actually wrote to the Council in relation to it, but they're wishing to pay for department paid testing. They will only pay an employer, and they will only pay a vet.
So that's, I rest my case, that a corporate-owned practice so cannot do TB testing, so the large animal that is going to be dropped, they won't be providing the service in the area where they buy in, because they cannot draw down their wages for doing TB testing.
Just to clarify this then, Ms Malone.
I was going to say, Chair, it might be a matter that the Department are better placed to answer than ourselves, because it doesn't involve...
So we can get clarification.
Well, the department, it's black and white what the department are doing. The clarification has to come from the Veterinary Council side, how they're going to get over this hurdle. I think the department are very clear. They will only pay an employer or a vet. So I'm asking the Veterinary Council, how does a corporate-owned practice draw down their payment for doing TB testing, or does it mean that they won't be doing TB testing going into the future? Or, and if they say they have no involvement or no role in ownership, I think that's a major stumbling block that has to be overcome going forward. They'll have to find somewhere around.
That's my understanding, is from that letter.
If the vet is not the owner,
he has to be the employer. He's
the employer, rather.
So he could have a partnership arrangement with an owner. He may also be the employer of two vets in it. He may be a sole trader. I don't know. Working with a company in some sort of a contract.
Yeah, but use the example where there is a corporate entity and the vet is the employee. He's not the employer. Who's going to get paid?
Again, it's the Department of Agriculture would clarify it better. Yeah. But my understanding is that they will...
Is there examples of this around the country at the moment, would you say?
No, I don't think it's an issue at all, actually.
It's certainly not a matter that has come to the attention of the Veterinary Council. It's not a matter that has been considered on the Council agenda to date.
Okay. Okay. Deputy Fitzmaurice, next.
Right. First of all, if I am a farmer and I pay the vet that comes out to me, has that vet or some vet that got the licence from me to practice, is that the person that has to get the money? This is what I know more than the TB thing.
as a regulator, Deputy Fitzmaurice, we, the council, have never been involved in terms of pricing or payment. Is, you know, no more than, say, the
I
pharmaceutical
didn't ask you
regulator
that.
that's involved.
I says you give a license.
Yeah.
You said a person, the license that you give is to a practitioner.
Yeah.
That has the certification and everything.
Yeah.
So what you are saying is that that person basically is the only one that has that license, so that's the only person that can charge him. Or if it's somebody working for a VIT, that is a VIT. But are you stating to us here that that VIT, if they're working for somebody that isn't a VIT, that they shouldn't be paid?
No, we're not stating that. We have no control over you know, who bills and who gets paid. That's just
one second. When you said, you spoke earlier on, and you said when you give out a license, there's things about service.
Yeah.
And by the way, will you tell me what is the hours of service? You said there's 24 hours. What is the mandatory limit or the mandatory time that a VIT is to come to a farmer?
So attached to the licence is...
I'm just asking in general.
Yeah, is making arrangements for the provision of 24-hour care, so for emergencies. So if I'm a vet and I am away for the weekend, I might ask my neighbouring practice to provide call for my clients during that time. So equally, say, practices around Leinster might refer matters to UCD Veterinary Hospital. So it's so that there are arrangements in place for the provision of emergency care around the clock, and that is linked to the licence, the certificate of suitability for any premises.
So when you give out the licence, if I'm the VIT in the area and 3 more VITs in the area decide we're going away for a lovely weekend, and there's someone 40 miles away that said, yeah, we'll cover you, is there any regulation on the price?
No.
No. So you're leaving it wide open under this, that a whole county could be left with 1 VIT over a weekend if everyone took it off and I was the person that said I'll cover it. And you think that's a good service to farmers and you're the veterinary council?
And look, I mean, there's been no change in relation to, you know, to that requirement for 24-hour provision of care. We don't and we can't control every facet of every practice around the country.
Look, let's open this out and we're dancing around here trying to be careful of legal and all of this. Let's put it out in the open. What's happening in this country at the moment is that there is corporate identities coming in, trying to buy out practices, trying to control areas, and they will dictate the pace and they will dictate the whole lot. So let it out in the open there. You're trying to dance around it. I know that you're under certain legal things. But for farmers and for a service in rural areas, we are seeing parts of the country, I'm not going to name any, but there are deputies here from some of them, where it is scandalous what farmers were being priced and the service they're getting. And are we going down a road that we're going to let English corporates come in and destroy the whole industry, or are we going to bring in whatever legislation or whatever way it has to be nailed? Second of all, question for you. When the decision was taken, can you name the people in December 17 at that meeting, or how many is on it? And do you think that anyone had a conflict of interest?
I mean, you talk about, you know, service in different remote areas, you know, parts of the country, be it Donegal, be it, you know, Mayo, be it Kerry. There are, I suppose, without question, there's the potential for shortages of vets around the country, and that's nothing to do with ownership. You know, there are loads of challenges for the professions. That's an area that we hope the council will be able to assist in terms of providing research, some analysis, and the data that we hold in time. It's referenced in our strategy. Your second question in relation to members of the council present at a council meeting when a decision was taken, I don't have the list of members on me, I'm being honest.
Can you forward it to the chairman?
That I certainly can, but what I can say is that any decision of the council is a binding decision, regardless, once that meeting is quorate, regardless of you know, who sits at that table. And all members of the council, when they sit at that table, wear public interest hats. They don't carry their own interests. They don't, you know, they don't peddle for their own, you know, for their own vested interests. They sit there as a regulator wearing public interest hats, bringing particular expertise and experience to bear.
they would have to acknowledge to the others if there was a conflict of interest, would they?
Absolutely. Frequently, you'll see committees and council members leaving, absenting themselves, having declared a conflict.
Could you send that list to the chairman? And could we get that as soon as possible? The one thing, is there legislation or is there something that can be done? Because like we're dancing around, there's a fourth party here that's nearly the invisible man, but it's the most important person, to be quite frank about it, because they're the new person in the game. There are none that everyone is saying doesn't exist, but they're there, and whether we want to admit that or not. Is there legislation or something that we can make sure the system we have in a lot of parts of this country, the VITs and the service they give is second to none. You can get a VIT in most parts of this country quicker than you can get a doctor if you were sick. Now, we are in danger, whether we want to shy away from it or not look at this invisible thing, we are in danger at the moment that conglomerates are going to come into this country, mop them up because they'll have the money, and then the farmer is the one that will pay the price, and sadly the animal is going to pay the price because you wanted the service. Is there something, be it through the Department of Agriculture, through government, through this committee, or through the Veterinary Federation, is there something that can be done to block this type of a loophole that's in the system, to make sure that the system that has worked for so long is going to be left?
I don't believe that it is sustainable for ownership to be restricted to profession. It isn't the case in relation to medics, it isn't the case in relation to pharmacists, it isn't the case in relation to dentists, and I don't think it's a sustainable or necessarily a wise provision in relation to veterinary. I'm not sure that the esteemed House of the Oireachtas would be enabled to pass legislation to that effect, and I'm not sure any member of the High Court bench would approve of any such legislation, but ultimately legislation is a matter, you know, for this committee and for the Houses of the Oireachtas. That is the honour you're charged with. I do think that there is a role for the Veterinary Council. Yes, there is the potential for shortages of vets in different parts of the country. There absolutely is. Is it something that the Council has on its radar? Is it an area that they want to take some action on and be involved in? Yes. The Council has access to a huge amount of data. No great analysis of that data has been carried out to date. One of the strategic objectives identified by this Council is to seek to influence and inform and engage with partner bodies. It is potentially open to the Council to carry out some research on all of the information that they have. So at the moment, the Council are sitting on data for every registrant, so what age they are, where they are physically in practice around the country in terms of geographics, what area of practice they're in. So in theory, is it open to the Council to be able to foresee potential shortages around the country 10, 15, 20 years down the tracks? Absolutely. So I would hope, and the Council are looking at the potential to carry out some research, to maybe work with the Department in terms of influencing policies around these kinds of areas, because you're absolutely right, Deputy Fitzmaurice, areas of very remote practice potentially will be under threat, and that is an area that all of society needs to be concerned with. So yes, I believe there is a role for the Council there, but whether or not there's a legislative basis to be involved in that, I don't believe.
Can it not be made mandatory that a veterinary a person, when you have the certificate to be a veterinary inspector or a vet, that a vet has to own the practice, or fine if it's the bank or whoever, we're not talking about that. What we are talking about is hidden money from out abroad of conglomerates that's coming in. And can we not make sure that the person you pay is either an employee of a vet or that they're a vet that owns it? Because if we don't do that, we are walking a lot of the country, because look, at big business is big business, whether we like that or not. And we are going to see areas of this country that you might travel 50 miles to get to this.
Scanlon.
Yeah, if I could. In fairness, we've never had as many registrants on our register as we currently have, and yet there is always, and it is, as a registrar has pointed out, nothing to do with ownership. It has been for 10 years or more quite difficult to get vets to work in large animal practice, which is the tougher end of the game, longer hours, tougher work, and often the remuneration would not match what expectation would be. The money is simply not in it. We need only look at what the beef industry is saying, how cost of production is below, cost of beef is below cost of production, and if the person who's involved in that has to pay for a veterinary service, you can see how the pressure would be at all times to keeping those costs down. So it's very hard to get vets to work in rural parts, even on the east coast, even on the northeast coast, even in the centre of the country. It's quite hard to get vets to do. Yet we have.
I'm in the west, which is generally the poor relation, and I will say one thing: we have a good veterinary service in a lot of areas around, very, very good. And I do think, and I'd say this openly to you, for youngsters that want to go into veterinary, generally you have to have, I don't know, 580 or 600, 570 or 80 pints. There's many a person that have been brought up that might have 520 or 30 and they never get in. They'll head off to some other country and have to become a vet through another door. And I'd advise you to look at that situation as well, for the simple reason there's many a person that might be damn glad to handle those bigger animals that you talk about. I know that there's a lot going for the smaller ones, but there's one thing sure, that in my own neck of the woods, we have a great service, I will say that. But if we keep going down the road that we're going down, of conglomerates coming in, we'll probably have one vet in the west of Ireland.
Two things, if I could, just 2 points from, thank you very much, Daly. I'd agree with you completely. It is something we are looking at. It is something that's, that we're looking at, the provision of the education, because in fairness, there are more now going abroad than there are even, not even so much more, but there are many, many more going abroad. And when we look at it in numbers to our own college, so perhaps there is time that we needed a second college, and perhaps that's definitely the case. But I will say to you, we're extraordinarily proud. We're extraordinarily proud of the service that is out there, the veterinary service, in every parish, in every country, extraordinarily proud of it. But any employer of vets at the moment will tell you to try and get, when you put in an ad to try and get a vet to fill for those sort of duties, it is very, very hard to get them. But just
okay. Deputy Cahill, we're rounding up now. Deputy Cahill and Deputy Pringle.
Chairman, first of all, I think there's an awful lot of inconsistencies in what we're hearing from the Veterinary Council today, and I have to say I'm disappointed. We have a model in this country that has worked extremely well. And the welfare of the animal and the welfare of the animal, I think, has to be paramount. And I've underlined a few statements here in the presentation. Ownership bears no influence on the provision of veterinary services. I'm not going to swallow that pill anyway, and unfortunately, we have an example already where a layperson or a copper buying a practice has had an influence on the provision of veterinary services, and an area has been left without it. So that's blown out of the water already. The clinical discretion of the veterinary practitioner is paramount, acting at all times in the interest of animal health, welfare and public health, and this decision brings clarity to the matter. And in my mind it does, because the welfare of the animal, and often having an uneconomical call to do, maybe going out to a call where you know you have an earthly hope of getting paid, and vets are doing that and doing it on a regular basis. We've seen this corporate structure gaining ground in other countries, and definitely the service being provided to farmers in those countries isn't like what we've been used to, what we've grown accustomed to in this country. As Deputy Fitzmaurice said there a minute ago, you pick up the phone and you ring for a vet, he'll be in your yard within a half an hour, no matter what hour of the day it is. That's a tremendous service. And to say that it shouldn't be, that the service, the ownership of this shouldn't be controlled, I take issue that that the Veterinary Council say that they've no remit in regards of ownership, because unless there is a remit there, and unless there is strong ethics there, the welfare of the animal is going to be put at risk. And at the end of the day, and I'm not questioning Vits ethics, because they have proven they have their track record to back up the way they put animal welfare as top of the list. But a corporate ownership won't put that top of the list. And, to say that they'll ensure there's 24-hour service there. We see there might be 24-hour service there, but the cost of that service, we see it in other jurisdictions, where a call-out would be at an exorbitant fee, where it's just it's not economically viable to call out animals, to call out a vet to an animal. And that will bring animal welfare, issues. And, it's right, the corporates, if they're getting involved, and the question of testing hasn't arrived as yet because they're only cherry-picking the practices in cases with very specialised practices or large small animal practice in large urban centres. But they will go into the dairy areas of the country where there is large herds at the moment, and they will go in there and cherry-pick the large practices there, and they will form a huge practice in that area. And we've seen this model in the UK, and you'll have your vet coming into your yard once a year and giving you the programme for prevention medicine rather than providing a service to you. So I am extremely disappointed that we have a veterinary council that's abdicating their role in regard of ownership. And now they can say that the legislation says this, but for 13 or 14 years the legislation said different. And I just can't understand how the interpretation of the legislation can change after 12 or 13 years. But, I know we'll be discussing this as a committee, after the representatives leaves. But in my view, if the ownership of a practice, if the legislation doesn't allow it to stay in veterinary hands, I think the legislation has to be amended, because we have a veterinary practice that's working extremely well. We have there's absolutely no welfare issues as regards the veterinary practice in this country, and now we're going to go down a road where corporates are going to have their say, and we have seen it already where a practice has been closed for whatever reasons, and the vets coming to the vets who are working in that practice coming to a locked door. And to think that that the service that we have known, that to think that will be provided by corporate structures going forward to rural Ireland just won't happen. And I think it would be. And I had a lot of vets talking to me over the weekend, and a lot of them, it would be an economically for themselves personally. It would be economically a good decision if corporates could buy out, because they would be in a position to sell their practice and retire. But to a man and woman, they were against. They were against this practice, and they feel that the service that they pride themselves on will not remain, and that the whole for that fabric and that veterinary structure that we have in Ireland will be seriously undermined. And the final question I would ask to the Veterinary Council is, do they feel that to regulate all the aspects of the delivery of veterinary service to the public, would it be beneficial to the Veterinary Council if there was an amendment to the Veterinary Practice Act 2015 confining ownership of veterinary practices to veterinary practitioners only? And that's the final question I would ask.
Next Deputy.
Thanks, Deputy Cahill. The Council are absolutely confident that they can effectively regulate the practice of veterinary medicine under the current legislation. Absolutely confident. We have a range of regulatory tools which we will use as required. If it's a case over the coming years that we feel that there is a vacuum or a lacuna, well then we will come and we will seek legislative change. But at the moment we have absolute confidence that we can effectively regulate under the current legislation.
Last.
Thanks, Chairman. I just want to I think it's two questions. Go back to this hypothetical situation again, but basically, so you're licensing the veterinary, and the third party you have no role in or anything like that there employs a veterinary, and they decide actually to get rid of him and go and open up in somewhere else, so they have to employ another veterinary. Who oversees the conditions that veterinary is employed by under use? They pursue the practice.
So the Council are not and never have been involved in terms of terms of employment between,
No,
say,
I'm
a
not-
vet and...
Yeah, but the conditions of the veterinary practice, of the practice of being a vet, so basically the hours of service, stuff like that there, that you say that you regulate, you oversee that.
Yes.
So basically, I can get rid of one vet and take on another vet, as long as he's registered with views, that's okay.
In theory, but what you would have to do is that the registrant who is seeking to become the licence holder for the premises would have to apply to the Veterinary Council. So they would have to undertake, particular, provision of 24-hour service, or, whatever particulars that the council will request in time. So it's not as easy as taking one vet in the door and pushing another out. That's not the case. So the council will always have oversight, because the clinical discretion sits with the licence holder. The licence holder will be asked to be responsible for all matters relating to the practice of veterinary medicine in that practice. And it's not, so ownership, regardless of who owns a premises or a practice, the power sits with the licence holder, who must be a registrant with ourselves.
Yeah.
If I could also add, which might help, it's non-transferable. So you can't remove one vet and put another vet in. If a certificate was issued to the vet you wish to remove, that certificate comes back to council. Yeah. That practice, the service is gone. Another practitioner applies for a certificate to open a veterinary service to the public at and from number 1 Upper Drumcondra Road again. Then we go back, we visit, we look to make sure the standards are there.
No, but,
sorry?
But no, the vet is in 1 Drumcondra Road.
Yeah.
The third party decides they don't want that anymore. They're going to number 1 O'Connell Street.
So it's the vet that's moving, or?
No, the practice moves, the premises moves.
Moving.
And they employ another vet.
From a new premises.
Yeah.
That's a new certificate entirely.
So it's for you.
Yeah.
So you grant a new certificate for them.
New certificate, yeah.
Right.
Absolutely.
And so then the original vet in the first place, can he continue to practice because he has a certificate from you?
Absolutely, except as there was being said there that there could be other contracts that we have no control over that he might have entered into. People do enter into restrictive, whatever, not restrictive.
The third party could have taken the customers all the way with them.
Whatever way they'll sort that themselves, the certificate of suitability holder is the person that is providing the service. It is to that person, that vet, and their registrant partners that the public are coming to. So the clinical records, which I know there was a question coming in, I think it was Deputy McConalogue, the clinical records are relating to the certificate of suitability, which then there's a name vet on that. The medicines are attached that way also. And the medicines are very, they're a very big animal remedies regulations comes in across on them. So there's other regulations and legislation covers those also.
Just a last question, Chairman, if you can. Just in relation to border areas, and say the practice is based on the northern side of the border with service on the southern side, how does that regulatory regime work then?
So any practitioner looking to practice must be associated with a premises licensed by ourselves.
There is cross-border practice recognition. There is a cross-border practice recognition where treatment of animals from across one side can occur across the other, but it's restricted in the medicines usage and the medicines carried and the medicines prescribed. So there is an allowance for cross-border practices. But in fairness, as the registrar has said, by the letter of the law, but we don't want to get into boats coming into harbours south of borders or north of borders, to the letter of the law, to practice veterinary medicine here in this state, you must be practising either with your own certificate of suitability attached to a premises here in the Republic, or your name is on that certificate, who's in someone else. Sorry. So the certificate would have the certificate holder's name plus all the other vets, nurses that are attached to that certificate on it. So you either have to be as an attachment or you would be the cost holder.
It's one last question. This separate question just occurred to me now. If I have a complaint about a veterinary practice to say that they're not providing the 24-hour service or they're not providing, can I make a complaint to the Veterinary Council?
Absolutely.
Yes.
Not that we want you to be doing that every day,
we
usually find that service is quite good.
We deal with complaints against individual registrants, and if there are issues of concern in a particular practice, yes, they can be directed to ourselves.
And they'll be dealt with in a timely manner.
The council will consider it and, depending on the circumstances, take appropriate action.
Right, okay.
final question, Deputy McConalogue.
And thank you. Just a follow on, Mr. Scannell, in relation to my question which I threw in relation to Thomas and the client list of a practice. That is, in the case of a lay ownership, that is owned by the lay ownership, am I correct, rather than by the certificate of...
You are, as you say, and I can understand where the question is coming from, and it is a question that will obviously burn minds of registrants out there. But bring it back to first principles. The provision of the service for the very first client to that particular practice was to the named person on the certificate that we granted to allow the door open in the first instance. So in fact, if you follow first principles, that's a client of that man or woman that registered. Okay. Client records. Client records. So in fairness, I think it's the client actually owns the record. Legally, I think
so. In the case, say that you have, in the case that you have a 4 or 5 man practice, and that practice then has one certificate of suitability for clinical oversight of that practice. So there's one person, one vet in charge. Okay, they're all employees of a lay company. So in that instance, and the lay company has the premise of repair, but in that instance, and it's important, I mean, in that instance, who has the clients?
Well, arguably, the client list is an asset. So, I mean, where that ownership sits, has it been purchased, has it been sold?
Okay, so the lay owner could own the client list. Okay. Pardon?
I would imagine it would depend on the local contract. Whatever arrangement the certificate holder has entered. But as we have clarified, he must not, or she must not, enter any arrangement that is likely to affect their ability to uphold the code, provide the service, and do whatever.
And is it the case that a lay owner can decide to close a practice even if the person that holds a certificate of suitability doesn't wish to do so? Because, and just my point to extract on that as well, like, I mean, overseeing the decision made by yourselves to permit lay ownership is the fact that it is your belief that that ownership bears no influence on the provision of veterinary services. Now, if it's the case, and you therefore don't see a role for yourself in terms of acting outside the remit of what is silent in the Act, but if it's the case that a lay owner can close a practice against the wish of the vet who operates as a certificate, holding the certificate of suitability, then that patently shows, even in that extreme example, that the lay owner and somebody who's not a vet does have control and does exert influence on the practice and on the exercise of veterinary medicine for the people they serve.
I think in that scenario, you're probably looking at the contractual relations that are in place. So in theory, you might have 2 vets based in Kildare Street, and one vet decides there's a legal dispute, and one vet decides to lock the door. There are matters, legal matters.
But my point is that's between 2 vets. But let's say it's between 2 vets, right? That's between 2 vets, both vets being subject to the code of conduct, and both vets being subject to actually having to have the welfare of animals at the centre, okay? But if it's not a dispute between the 2 vets, where you bring in lay ownership, the lay owners don't have any responsibility to the code of conduct. They don't have any responsibility to the welfare of animals. Yet it appears that they can make a decision to close down a practice and prevent veterinary medicine being provided.
But all of that turns on the individual specifics of the legal relations in question. So in the same way, if Cather fell out with his landlord,
I take your point.
There are legal matters that we just cannot control. Regrettable, very often,
that's
when
fair
legal
enough.
disputes arise. We can't control every facet.
No, I take your point in that, but it certainly is possible. And it certainly speaks to the fact that ownership does bear an influence on the provision of veterinary services whenever lay people are involved. It does have an influence. And we've seen that already come into play, where lay ownership does have an influence. And that goes against the grain of what the Veterinary Council is trying to achieve and oversee, as in it should be only vets having control. And I would argue that by the change that has been made, allowing lay ownership come into play, we now also see a level of lay control over veterinary practice through that. And I would bring that back to saying that in terms of the Veterinary Council, making that decision in the first place, it would have been appropriate, and I know the law was silent in the matter, but it would have been appropriate to actually bear that in mind in terms of your rules of conduct, specifying that it should only be veterinary practitioners that can own practices, the reason being that it should only be veterinary practitioners that have control and influence over the provision of veterinary medicine. And whenever lay owners are allowed into that, they interfere with that and they then take on a level of control. And the only way you can avoid that, and these are lay owners not having any recourse or any responsibility to the welfare of animals or the code of conduct which veterinary medicine practitioners have to go by. And by allowing them in, you're allowing that non-veterinary influence into the conduct of medicine in Ireland. And I think that's why we're seeing veterinary practitioners across the country being so opposed by and large to it. The Veterinary Ireland's own survey would show that their survey was 86%, but I think there is a widespread concern and lack of support there. Now, the other point to make is in relation to cost. And I mean, so far, some of the evidence is what we're seeing is cherry picking. That's what we're seeing where it's sold. The company comes in, they want to keep the big clients, they want to keep the small animals, they want to keep the profitable part, and they want to cut the rest adrift. And where you have a lay owner come in, their primary motive isn't to look after the animals or to follow the veterinary code of conduct. Their private interest is making a profit and is money. And that's their driver, which they're coming in. And that then locks horns with the veterinary practitioner's obligation to have at the centre their code of care for the animals. And these two things conflict. Now, if the lay ownership didn't have control and definitely had no influence, then so be it, it could be way out there. But in theory, the concern would always have been that they would have influence, and we've seen so far in practice, there's only a very small number of sold, but we've already seen in practice that they do have control and they do come in on top of it and interfere with the vet's operation and ability to carry out their code of conduct. The other thing that comes into play as well is pricing. So a vet is supposed to have care for the animal, is supposed to respond to emergencies, and is supposed to have the care at the centre. But whenever you can come in and cherry pick the big and let the smaller clients go, and they can go and fend for themselves where they want to go, but it's not our responsibility, and then the calls you don't want and which are unprofitable, you can put a €500 charge on, so that it's way over and above the cost of the cost of actually responding to such a call. Well, that will never come on the vet's desk, quite possibly. You know, they won't get a call if it's costing €500. And that's not going to interfere or breach with their code of ethics in terms of care in theory, because the call won't come to them, because there's a €500 fee in it. But where's the animals? What happens to sheep? What happens to, the old, the animal that's worth less than €500? They're not being looked after. Whoever, they can go to their own devices or die on their own accord, or certainly it's not a vet that's looking after them. Yet, vets across the country want to ensure that in the carrying out of their duty, all that is looked after, even in cases where it's not necessarily profitable. And what we're seeing in evidence now is profit is starting to rule the roost. Farmers are not getting the service, particularly those that are not offering a profitable customer outlet to a vet, are not getting the service where lay ownership is coming into play. And vets are very, very disturbed by this interference and them being able to carry out their job and what they are all very committed to. And I think, that's why we need to, that's why I think the decision you've made is it needs to be revisited. And if it's not possible that it happens in relation, for you to do it as the Veterinary Council, I think it needs to be revisited by the Department of Agriculture and by the Oireachtas in terms of the legislation and looking at ensuring. Because I think, and it's clear, there's no doubt, lay ownership means lay control, lay interference, profit ruling the roost rather than the duty of care. We've seen it internationally. It's going to happen very rapidly here unless it's addressed, and I think we need to address it.
Thanks, Deputy McConalogue. A lot of points to return to. Look, there's been a huge amount of debate about corporate ownership. It has been challenging for the professions, for the council. This is not a decision that the council have taken lightly. In the consultation, just shy of 60% of those surveyed were anti-corporate ownership, 40% for. So it's entirely contextual. So you see vets at certain stages in their career being more open to corporate ownership, say veterinary nurses, pro-corporate ownership. It varies entirely depending on the context. This committee will take its own legal advice, as to what is sustainable. Yes, the council acknowledged that it is a changing environment. Yes, there will be challenges. Of course there will, played out in the nuances of these decisions, across the country over the coming years. The council will keep an eye on all of this. They are not going to undermine their own function by allowing something, to come in that they can't regulate. The council is absolutely confident that it can regulate the practice of veterinary medicine. Yes, they will be revisiting, reforming, revising certain aspects, of their procedures over the coming months. All of this will be kept under review. The council won't be found wanting, to play its role in all of this. But the council is not requesting legislative, change or amendment at this time. Of course, it's open to this, great house to bring in whatever laws it deems appropriate. But the council hasn't arrived at a conclusion that any such legislative amendment is required. In terms of pricing, that's just outside of the role of a regulator. It's just not within our gift. Maybe life would be a lot easier if it was. But look, the Medical Council can't set the fees. For doctors, the Pharmaceutical Society can't set the fees and the charges that pharmacists introduce. Similarly, the Dental Council, we're a regulator. We have a public interest focus in the regulation of the practice, but we can't control every facet. We acknowledge that there will be loads of challenges in the years to come, but the Council will not be found wanting in rising to meet those challenges to ensure effective regulation in the public interest.
And control those elements such as price, and you allow the ownership in, which is driven by profit, then you don't have control. You can't control it because, I've seen it in my own county, out of hours calls go up to €500. Then, the veterinary, vets being available to carry out their duties simply is not feasible in that position. So you don't have control over ensuring that there's veterinary service whenever you don't have control over that particular aspect. Just one final point in relation to cherry picking of customers and let's say let non-profitable ones go. What is the obligations on a particular practice? And I say there's a situation in my own county which we're well aware of at the moment, where a large practice is closed down, which was bought by lay owners, removing a very significant veterinary service to large parts of the county, there's a real difficulty and challenge there now in relation to how they are going to be served. And I would ask you for a comment in relation to that particular instance and ensuring that there's a service in that area where there isn't a practice, and from a veterinary council point of view, because it's important. But one other question in relation to the cherry picking of small or of customers and leaving small customers go adrift. What's the situation in relation to the obligation on vets in that scenario, where somebody is no longer a customer of a practice? What's the obligation in any vet to provide a service to them, obviously, particularly in cases where it might not be seen as profitable to do so?
Yeah, in relation to, thank you. I would concur completely with what the Registrar has replied to Deputy McConalogue, and in fairness to Cahill, I would like to say that every one of your concerns was what drew us into debate and discussion and thought on this issue, and we are quite confident, and as I say, I would stand firmly with my Registrar on that. We are quite confident that by putting the provision of the service into the hands of the vet and the vet only, and that the certificate of suitability in primary legislation is specifically the registrant only, and that if the registrant wishes to close, open, move, change, it's the registrant's decision to do so if something is occurring in relation to control that they are unhappy with, that in any way affects their ability to provide that service. They have the ability to say they can move next door. What I would, the question you were asking is the after-hour service. In fairness, we don't. The Council does say that veterinary practitioners are under an obligation. If an animal is in need of succour, emergency treatment, we cannot turn away. We cannot. But in fairness, you'd usually try and come to some arrangement with someone somehow that may be close enough to do it. It's not that somebody sitting in County Kildare must answer a 24-hour phone call from, if it were Donegal, and that they must go if the farmer says to them. But if there's an animal in need of veterinary attention, we would be asked to go. I don't know if that quite answers. But the Veterinary Council wouldn't say you must provide a service for Mr. Reardon, farmer who has only 10 animals, if you're going to provide it for Mr. Jones, who's right next door with 100. We wouldn't get involved.
Even if they're not a customer of your practice as such?
Even if they're not a customer of your practice, if there's an animal that needs veterinary, now first aid, we're talking about first aid to carry us from the middle of the night across into the morning when the local practice can deal with it. Yes, it would be expected.
And where you drop or where a veterinary practice decides to drop small customers because they're not profitable, what's the obligation on, where do they go then in terms of getting a service?
Well, in fairness, practices, and it's not exactly the same, I appreciate it's not exactly the same as what you're saying, but practices may refuse to do equine services anymore, or whomever they had doing a particular service within the practice, and that person retires, nobody else is doing it, they may choose not to do that service again. So the Veterinary Council wouldn't be saying you must do X or Y or Z. On the one, and it would be a concern, where somebody who was of a small farm and was not going to get his service, but the larger farmer would. The market usually finds its own level. If they are being left behind, someone is going to have to give a service, and that someone will also offer to the bigger client, and will also come in perhaps at a far more better priced, and therefore it would be in the interest of the larger group to take the smaller fella as well. It's the way the market actually works.
Yeah, I think with the danger with lay ownership, and I think what we're starting to see is that the lay ownership is coming in, they're dropping their smaller clients, they're keeping the larger ones. So all that's available in an area then is the unprofitable clients, which in a situation where maybe there's not a big oversupply of vets, we're not going to see vets coming in and starting up in an area where there's only the pickings of non-profitable customers. So that whole movement towards lay ownership is going to create that, and is starting to create that problem, and it's something which can't be let actually, continue, or it will show itself.
I think the point has been made very well there, in fairness.
Thank you, Deputy.
Yeah.
And we will be monitoring at all times. We will be monitoring the rollout of this as it goes along.
Lombard had a brief point, I think, before we wrap up.
Yeah, very brief. I think Charlie will have covered most of it. It's about the 2005 Act and about where we're going with the 2005 Act. Most commentators would say it's silent on major issues of ownership in particular, and it would need to, and we would heard even, we won't say today, that there's other issues that need to be looked at as well in the 2005 Act. I'm somewhat surprised by your view that it doesn't need to be amended or looked at or reviewed. Has that been a decision taken by the Council itself, that 2005 Act is sustainable going forward, or has there been much debate at the Council about the Act itself?
There has been lots of debate, Senator Lombard. Absolutely an immense amount. And the Council has not arrived at a decision whereby they feel that they do need legislative amendment. That's not to say 12 months, 18 months, 24 months, a few years down the line, depending on circumstances in the environment. That's not to say that at a future date the Council may seek legislative amendment, but at this point in time the Council has not made any decision to seek legislative amendment.
And the Council has debated that at a major level in the last few months or years?
I suppose it's fair to say that the Council has examined the Act in great detail over recent years.
In fairness, there are certain parts of the Act that we would like additions put into, and not but this specific one. If your question, Senator, is relating specifically to this.
No, more the Act itself.
Yeah, in general we have, and there is a list, a to-do list that we would like this change in the Act, and items where we have come across where we would like to do something, we went to do it, and then we got advice that actually your Act isn't giving you enough cover to do that, you will be challenged or whatever, and you really needed extra words put into the Act. They would have been relatively minor, and hence we haven't been coming in. So, but there are several items that we probably would look at.
Sure.
Okay. Thanks, members. Thank you very much, Ms. Muldoon and Mr. Scanlon. I think it was a very informed debate. Thank you very much. We're just adjourning slightly for a minute to go back into private session for a couple of minutes. And I'd like to thank you very much for your attendance here today. The meeting is adjourned for 2 minutes. Suspended, sorry, for 2 minutes.